2005.
Counsel, let me stop you. Let me stop you. I have to agree with defense counsel. I don't think you understand the purpose for which I set bond. You want to try the case today. Tell me why this individual is a danger to himself or others. Tell me why there's a danger that he won't show up. That's what I'm supposed to be determining today.
Okay. Well, I
I'm
can't.
not trying
I can't
a freaking case.
I understand, but I can't say that he's not going to show up because he doesn't have a criminal history. So I understand that. But he's charged with homicide second degree. And we can't just...
I read the file, counsel. I know what he's charged with. Tell me why he's a danger to himself or others.
Because he just killed someone and it's not self-defense. The other individual did not...
And you know that how?
Your name?
Anthony Tyler.
Good morning, Mr. Tyler. We're trying to get the prosecutor connected.
Good morning.
Well, I'm here, Judge.
All right. Good morning, Mr. Muhammad.
Good morning, Judge.
All right. This is defense motion. I think, no, this is plaintiff's motion to adjourn.
Well,
Prosecutor's motion.
Judge, this got amended to a PCC. And so today's a PCC day and we're setting it for exam.
Ah, okay. Gotcha. August 21 or August 28 work for you two?
Your Honor, is it possible to set it sooner than that on August 7th?
Heather tells me no. That's Judge Martin's day, so she had Mr. Muhammad tied up.
Oh, I'm sorry. In the past, I've had cases before one judge that gets set for an exam in front of a different judge. So is that possible?
All right, I had you and Heather both talking. I'm sorry, counsel.
Oh, I was just saying that I've appeared on other cases where the PCC is handled by one judge and 34th, and then the exam is set before a different judge.
We don't do that.
I
don't think you've had that with me. I don't like to set other people's schedules.
totally understand. I guess my concern is Mr. Tyler is in custody. This is a case from 2022. We want to get it moving. We understand the complainants are out of state, but for him to have to wait a whole month, basically, the 21-day rule, exists for a reason. So right. I'm concerned about us going out that far.
I certainly understand your objection to waiting, but I don't have too many options. I could give a special date if Mr. Muhammad is available, but with those other court duties, I don't know what availability he might have.
Is Your Honor available on the 31st of July?
Same thing. Somebody else, Mr. Muhammad's working in one of our courtrooms every Wednesday. That one's not mine, so I can't schedule an exam with him and take it away from one of my benchmates.
Understood. I guess for Your Honor, when is you're off until the end of July or August is what you're saying?
With Mr. Muhammad, correct.
Right. I apologize. Right. Off is the wrong word, but
Mr. Muhammad, do you have any other days of the week where we could schedule an exam?
I'm in court 3 days for sure in other district courts. And then one of them is it's sometimes a prep day. So I don't want to say it and then they have me set somewhere else.
I understand that. One of the days you're in one of the other district courts, can you reliably say that you'd be out by a certain time? So maybe we could do an afternoon exam?
Yeah.
I'm assuming this won't be a long exam, I'm gonna guess.
It won't. Yeah, I would say I'm sorry, 1 second, Judge. Let me just tell.
Sure.
Yes, I would say Monday because I'm in Garden City that day. So I would say for sure I'd be out by 12:30, 1 p.m.
Okay. So Heather's looking at Monday. We can get you in here August 5th in the afternoon. Can we get them in before then?
Yeah, that would work for the people.
You know what, counsel? Let's schedule it for August 5th. I've got a jury trial scheduled the 29th that the prosecutor told me yesterday she's got questions about her complainant. So if that goes down, Heather will contact both you and Mr. Muhammad and see if we can get you into the week earlier.
okay.
Well, Judge, on the 29th would be a little tough because the thing is with this case, the reason for all this adjournment and stuff is.
Yeah, that's right, the airfare, yeah, Heather just pointed that out.
So I'm available the 5th, though. We could just stick with the 5th.
I'm sorry I can't get it earlier than that.
No,
but
it's okay. I
we'll-
appreciate, that's a lot sooner than the
we'll
end of
set up the
August, so
5th.
I appreciate
All
that.
right, so what do you want to do? 2 o'clock, 1 o'clock? 1 o'clock on the 5th?
That works for defense.
So I'm sorry, what was that time, Judge? August 5th at?
1 PM work?
Yeah, can we do 1:30 just to be safe?
Sure, sure. All right, Mr. Tyler, you catching all this?
Yes, sir.
I'm
All right.
so sorry, Judge. So I just recalled that I'm gonna be completely off in the month of August. Well, for most parts of August, because we're having a in-county
Oh,
training.
that damn training thing.
Yeah. And if I recall correctly, I believe it starts on August 5th.
All right, you know what? Let's do this. Schedule it the 31st. Schedule TB. I'm covering her docket tomorrow, so she's not gonna complain. Anyway. All right, I'm gonna schedule it on Judge Green's 31st. Well, does that give you people enough time to get here, Mr. Mohammed? The 31st of July. 2
I think it
weeks.
should work. I'll
Okay.
I'll tell them it has to be
All
done that day.
Okay. Heather's gonna check the time right now.
Thank you.
12 o'clock work?
That
Yes.
works for defense.
Just remind me to let Tina know why we did that. We've got 2 files today. I want to take care of the quick one first. It's not
Okay.
yours. I've got a March 2024 drove while license suspended misdemeanor charge from Huron Township. I'm just going to give you a court date, August 8th at 9 o'clock. That's in front of me. So come back on August 8th, take care of this misdemeanor. All right? Got that?
Wait, me?
You. All right. I'm going to put you on a personal bond in the meantime. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court if you're not here on August 8th?
Yes.
All right. So we'll give you a paper notice for that. Now let's talk about your file, Mr. Becker.
Understood.
You want to set an exam?
Yes, sir.
How about August 21st?
That day should be fine.
11 a.m.?
That'd be fine with me.
Okay, that's all right with you, Mr. Bridges?
Yes.
Okay. All right, so we got an exam on the 21st, 11 a.m. That's live with me here. Anything else, Mr. Becker?
Your Honor, I would ask, Mr. Bridges asked me to ask this court to consider the removal of his tether. He does have a full-time job, Your Honor, at the airport. He works cleaning out cabins for the airplanes, and the company that he works for, in essence, has indicated, you know, the tether is somewhat of a problem. If I believe for them, if nothing else, just for appearances purposes.
Right.
I would ask, Mr. Bridges, I know, has been out at least over a week. He has asked me to ask this court to consider removing the tether. I do understand. We do understand and acknowledge the charges. However, Your Honor, I would indicate that this is a kind of a, well, I don't want to try the case, Your Honor. That's what we're asking the court to consider.
Okay, all right. Is this? Who's prosecuting this? Who's your is this is Patricia's prosecuting this one, Mr. Becker?
I'm not certain, Your Honor, on their
Ms.
behalf.
Mananash? Yeah. Hey, I gotta have some input from her on bond. On Zoom or in here, I don't care, either way. I just want to give the prosecutor a chance to weigh in, counsel, before I make a decision.
Understood, Your Honor. That's fair. It's funny, me and Ms. Mandanech actually have a case at circuit that we have to both Zoom in together.
I'm sorry, did you tell me all the parties on Peterson are on Zoom? Prosecutor, defense, everybody's on Zoom?
Everybody's on Zoom already, so I can let them know.
Thank you.
Is there anybody else here with Peterson?
Counsel, on the Bridges matter, Mr. Bickert has just made a request that we remove the GPS tether. Mr. Bridges works at the airport. He's got some concerns about his employer with the appearance of the GPS tether. That a pretty good summation, Mr. Bickert? We just lost Mr. Bickert.
I'm sorry, Judge, I would ask for just a brief indulgence, please.
Yeah, but I lost Mr. Bickert. Flipping technology. I never ever lost anybody when they were standing in front of me.
What day are we scheduling that for?
The exam was the 21st at 11.
I'm sorry, Judge, that was 8/21.
Yeah,
11 a.m. for the PCC.
Yep. For the exam.
Oh, 11 for the exam.
All right, I'm gonna have you step back till we get Mr. Bickert back online. Are we ready on the Peterson matter, folks?
Morning, Judge. Can you hear me okay?
I can.
Defense is ready.
People are ready, Your Honor.
All right, if you two put your names on the record for me, we'll get started.
Good morning, Your Honor. Sarah Bonomo on behalf of the people, P84189.
And good morning, Judge, to you and your staff. Robert Burton Harris, P81843, on behalf of Mr. Chris Peterson, who's present, zooming in from the Wayne County Jail since this hearing being conducted on.
Thank you. And Mr. Peterson, can you hear everyone all right?
Not really.
Just give. Not really? You want us louder?
A little louder.
All right, we'll try that. All right, counsel, I understand we've got two items up today, both from you. One is order of indigency, and the other is a bond reduction, correct?
Sorry about that, Judge. I was getting a call in. Yes, that's correct. There's two issues.
All right, well, let's take the indigency first, just because that happens to be on the top of my file. People have any position? I'm assuming you've seen the documentation, counsel?
Yes, Your Honor. I don't have any further information besides what he put in the motion, so I would have no position.
All right. So what you didn't tell me is any information so I could make a determination the guy's broke.
Well, I did include where he works, and I looked at my notes, and how much he makes per hour just escaped me, so that's why I didn't include it in my motion. I did indicate that, because Mr. Peterson is present, if you had any questions about how much money he actually had access to or made, he certainly can answer those questions for you directly. I don't believe that he makes more than $23 an hour, and I know that he was working part-time. So to the extent that he just can't afford investigators and experts in this case.
Okay. All right, Mr. Peterson, where do you work, sir?
Guardian Angel Care, which is my mother's company. That's a home health aid, helping elderly people.
I am, Your Honor, and I apologize. I'm having a lot of.
Mr. Bickert, I'm in the middle of something else right now. I'm sorry, Mr. Peterson. Why do you work part-time?
Said I also work
Why
with my
are you
father.
working part-time?
Because I also work with my father. He owns a lawn service company.
So you have two part-time jobs?
Yes, sir.
Okay, and how much are you paid hourly on both jobs?
With guardian angel care, I get paid 15 an hour. And the lawn service is, I don't get paid hourly, I just get paid at the end of the day. Actually, I get paid 15 an hour from that too.
All right, and how many hours a week do you work between the two jobs?
I'm not
Are
too
you
sure.
averaging 40 hours a week, 50 hours a week? How much are you working?
Probably like 20.
Then go get a third job.
Yeah, about time.
How old are you?
24.
Are you healthy?
Say it again.
Are you healthy?
Healthy? Yes.
Then you should be working 70-hour weeks.
Can I add something for the court's indulgence, Judge?
Not unless you got a job for him.
Well, well, what I was going to say is that what Mr. Peterson is not including is with his younger sisters and a cousin, who he also helps out with on a daily basis. So it's not that he's just kind of sitting around not doing anything. It's just that he has other obligations as well.
He ain't working as hard as he should be, I can tell you that. I'll sign the order. Let's talk about the bond.
Appreciate that, Judge. So I think it's pretty clear from the motion. I kind of laid everything out. He's 24 years old, no criminal history whatsoever, never been in jail, never been in custody. This case is a prima facie case of self-defense to the extent that, that will be the defense. Frankly, Judge, I don't even know, and this is something I'm researching, I don't know to what extent the prosecutor is going to be even able to argue that the decedent in this case was not violent. And so the likelihood of conviction on this charge is extremely low, to say the least. As I put in my motion, he, like I said, has never been in jail. The Wayne County Jail is not staffed and not appropriately staffed, I should say, to be able to protect him long term. And so the magistrate who arraigned him, after I explained the circumstances of this case, felt that because initially his gut reaction was to just remand him because of the charge. After I explained the details of the case, he changed that so much that he didn't even order a tether for Mr. Peterson, but he still kept the bond at a $250,000 cash amount, which was just completely unaffordable. Mr. Peterson is obviously not he's in jail. He doesn't make a lot of money to the extent that his family could afford to retain me. They don't have the money to pay a $250,000 bond. And so, Judge, I'm asking for a personal bond because there's really just no reason not to give him one. I think the best indicator of future behavior is past behavior. And this case, officers arrived. Mr. Peterson was sitting on the end of his driveway with a gun next to him that was made safe with his CPL and license on top of the gun. So he's clearly indicated that he's in no way, shape, or form a flight risk, and he's certainly no danger to the community based on what I said. Sister Counsel have sent me most of the discovery, I think, on their end so far. And so this was captured on video. You can see that what's on video supports what he told the officers to the extent that those statements are going to be admissible. So there's just really no reason to have him in jail other than the specific charge. But obviously that is not the only factor when you consider bond.
Thank you, counsel. Response from the people.
Your Honor, just to start, so just briefly touching on the facts, we have ring camera of the victim parking across the street from his girlfriend's house or his ex-girlfriend's house, a couple houses down. We have the defendant, which is the defendant's mother. That's her boyfriend or ex-boyfriend, I'm not sure. We have the defendant who's trying to ask his mother, is that the victim? Is that the victim out there? But he can't get a hold of her. She's in the shower. That's when the defendant and his cousin calmly, casually walk across the street, armed with a gun. The victim exits his vehicle, goes to the passenger side to approach them because they have already approached him. There's some kind of conversation that took place, and then the defendant shot at least 7 times, if not more. There's no gun recovered off the deceased. The defendant doesn't say he had a gun when the police come. The cousin doesn't say he had a gun when the police come. They casually and calmly walk back across the street, all on Ring camera, as the mother is hysterical. She's screaming, "Why would you do this?" He pulls up a lawn chair and he sits and waits for the police to come. I want to talk about the motion that defendant submit to the court. It says the shooting occurred at his home. No, it didn't. He was in the safety of his own home. He chose to leave the safety of his home and to confront the victim. He decided that in that moment, he's going to be judge, jury, and executioner. And then in the motion, it says the deceased has been abusing, stalking, threatening, harassing Mr. Peterson's mother, himself, and his family for years prior to the shooting. That's not self-defense then. He knows what he's doing. He went over to confront the deceased and he had a gun. He knew exactly what he was doing. The shortage of the Wayne County Jail is not permission for someone to get a personal bond. The fact that he's not familiar with jail, that's what the defendant's saying. I'm not familiar with jail and violent offenders, so I shouldn't have to sit in prison. He's the violent offender. The argument maybe can be made for someone on a CCW or a little possession charge. This is a homicide second degree. I think $250,000 bond is way too low for a homicide. I am asking for a remand of the bond, and I'm asking for an exam. And after the exam, after the court has the opportunity to review the evidence, then we can address bond, Your Honor.
All right,
May I have a last word?
Mr. Burton Harris, anything else?
Yeah, so for a couple things. The defendant's statements support everything that's on the video, and I don't think the sister counsel said otherwise. I'm not sure how she said that.
Hold on. I lost your audio.
Can you hear me okay now?
Back way up. Back way up. You blanked out.
Okay, so I was just saying that I just want to address a couple things sister counsel said, and didn't say. The video supports exactly what he told the officers. I don't know how sister counsel knows what was said, because she's correct. The Ring camera is from across the street, so you can't hear the conversation, but you see the my client backing up. You see the decedent coming at him and his 16-year-old cousin who was standing right there. So she's correct that it was across the street, and if I put it in my motion that it was at his house, that was just inartful on my part. But the shooting did occur across the street. So that's one thing. In terms of the reasons for confinement, sister counsel has flat out asked you to do something that's unconstitutional, in the sense that she wants a high cash bond expressly so he can't get out. It's not connected to dangerousness. It's not connected to any type of flight risk whatsoever. In terms of what the mother said, I'm not exactly sure why that's relevant at all. I cited in my motion multiple police reports, multiple criminal court cases that were prosecuted by this prosecutor's office for the decedent. So the question about his dangerousness and whether or not my client has the right to go and speak to somebody because he has a CPL and carry a gun, I think Your Honor knows that is his protected right, and that he can do that. The fact that the prosecutor has acknowledged and doesn't dispute this prior threat, stalking, et cetera, it honestly just kind of baffles me, because the idea that my client has to stay in his house when there is a threat that has been ongoing and outside is not consistent with the law. And so if Your Honor is inclined to do some cash bond, his family cannot afford to pay more than $4,000. So I would ask that you would make a $40,000 cash and surety bond with a 10% provision, so that they can post it. He can face these charges. He's already demonstrated he's not a flight risk. And in terms of him being in danger, I think we've already addressed that. And sister counsel hasn't said anything to dispute the circumstances of this shooting.
And Your Honor, if I can briefly.
Sure.
I guess the first thing is I'm not agreeing that there's been abusing and stalking and threatening. That's the defendant saying that. So how are you going to come back and say now it's self-defense if this has been going on? He knows what he's doing. He's also asking to drag the deceased through the mud about his criminal history, his past, and he's citing a 2005.
Counsel, let me stop you. I have to agree with defense counsel. I don't think you understand the purpose for which I set bond. You want to try the case today. Tell me why this individual is a danger to himself or others. Tell me why there's a danger that he won't show up. That's what I'm supposed to be determining today.
Okay, well, I
I'm not
can't
trying the
say,
frickin' case.
I understand, but I can't say that he's not going to show up because he doesn't have a criminal history. So I understand that. But he's charged with homicide second degree. And we can't just.
I read the file, counsel. I know what he's charged with. Tell me why he's a danger to himself or others.
Because he just killed someone and it's not self-defense. The other individual did not
And you
have a
know
gun.
that how?
Because the other individual did not have a gun. He even said to the police, the defendant said to the
Okay,
police.
you've told me all I need to know. You've told me all I need to know because obviously the only reason deadly force is justified is if the other person has a gun.
And what the defendant said, what the defendant said to the police and what his cousin
Your
said.
motion's granted, counsel. The bond is changed to $1 million personal. What's the next court date?
Thank you, Judge. I've heard your staff say that you were available for exams on August 28th. And our defense is free on that day as well.
28th of August, does that work for the people?
Yes, Your Honor.
And what time would this be, Judge?
How many witnesses do you think and how long do you think it's going to take us? Because I need to set it for, pick the scheduling.
I would probably anticipate at least 4 witnesses, Your Honor. And Your Honor, I'm sorry. I know you already made your ruling. Can I just mention one more thing just so the court?
No, because as you said, I've made my ruling. Now we're scheduling the exam.
Okay.
Defense, how many witnesses you think?
I'm thinking 2. Can you hear me okay, Judge? Can you hear me okay, Judge?
I think it's 1. All right, call it 1 p.m. on August 28th. Good day.
Thank you, Your Honor.
Thank you, Judge.
What do you got?
I need to speak with her.
Oh, hold on. Let's take care of Mr. Bickard. Mr. Bickard, I forgot about you.
I'm so sorry, Your Honor. I got disconnected.
Yeah, come on, Mr. Bridget. No, that's technology, Mr. Bickard.
And I know that's exactly probably why the court likes to do it in person. I was offered
no problem.
30 seconds.
Here's where we're at. For the prosecutor, I summarized your argument, which was you want me to do away with the GPS tether because quite simply the optics of the tether on the job are causing him problems. Is that a fair summation?
Yes, it is.
Judge, in response, I would request that the court leave the GPS tether on. In this case, defendant is accused of assault by strangulation and domestic violence. My specific concerns in this case are that the incident report indicates that defendant took complaining witness's phone at one point to prevent her from calling for help. I believe she was specifically trying to call her mother. Her statement indicates that defendant kept quote unquote cornering her, preventing her from leaving, and complaining witness went to leave the home and defendant dragged her back inside. So for those reasons, I would ask the court leave the GPS tether on to ensure complaining witness's safety.
Okay. All right. Mr. Bickard, I'm not comfortable getting rid of the GPS tether at this stage in the proceedings. I'm going to leave it as is. We've got our court date set. We do have something unrelated. It looks like you also owe us some money on a speeding ticket. Are you in a position to set up a payment plan?
Yeah, I already did it.
You got a payment plan set up? Okay. All right. Anything else, Mr. Bickard?
No, Your Honor. Thank you.
All right. Questions for your attorney?
Yep.
All right. We're all set. Thank you.
Thank you, Judge.
And Mr. Bridges, give me a call later today around lunchtime.
Sir. Okay.
Now, Mr. Bowditch, you can have the prosecutor.
Thank you, Your Honor.
Hey, Joe.
Yes.
I'm sorry. Would you check and see if we've got a Caitlin Martin?
We just took that, Mr. Commission under FCR 8.12 to conduct this hearing under the supervision of Attorney Mohammed.
Granted.
Neighborhood Defender Service by Kate DeMott Grady, P83667, on behalf of Mr. Wayne Bales, who's present with us here in the courtroom. Mr. Bales, please state your name.
Wayne Bales.
Thank you. Go ahead, counsel.
Your Honor, at this point, I am moving to withdraw. There's been a breakdown in the attorney-client relationship.
Counsel.
Your Honor, the people are ready to proceed.
We got civilian witnesses.
We have a police officer, no civilian witnesses.
Are you planning on hiring your own attorney, sir?
I was seeing if it was possible to be appointed another.
We appoint, you don't get to pick. We appointed.
Okay, I'll have to then, sir. I'll have to then, sir.
Have to.
Hire another attorney. I'll have to, being that she doesn't wish to represent me.
I don't think she doesn't want to represent you. I think that you probably aren't listening to her advice. That's what my guess is. Usually when there's a breakdown of communication between the attorney and the client, it's because the client's not listening to the attorney.
I understand, sir. But I was going to plead innocent, and she didn't want to stand by the innocent aspect of it. So,
okay.
I have to.
All right. Well, first of all, innocent, this is going to sound bad, but it's true. Innocent is not a word that we use in a court of law. It's guilty or not guilty.
I'm not guilty, sir.
I know that, or you'd be already downtown somewhere.
Right.
Okay.
Right.
So my understanding is there's a preliminary exam scheduled for today.
Yes, sir.
Okay. My understanding is she's prepared to do or was when she got here, prepared to do the preliminary exam. That's the next stage in the proceedings when you're pursuing you're not guilty.
Yes, sir.
Follow me?
Yes, sir.
The question is whether or not you waive the exam and just go downtown and fight the case, or if you go through the exam because whatever reason your attorney might choose to do that.
Okay.
So the question for you is, and that's why I said what I said. My experience has been usually when there's a breakdown in the relationship to the point where the attorney's saying, I can't represent this person anymore, it's because you're not accepting her advice.
I'm just pleading not guilty, sir. That's all.
Okay, and she's told you you can't plead not guilty.
She said it was against her advice, and I should probably hire another attorney.
Was there an offer that the prosecutor made to you?
Yes, sir.
Okay, and has she presented that offer to you?
Yes, sir.
And has she told you that she thought that was a good offer?
Well, that's going against.
Yes or no? Yes or no? Did she tell you she thought it was a good offer?
Yes, she did, sir.
Okay, and did she say, if you don't take this offer, then I can't help you?
Pretty much, sir. Yes, sir.
That's what she said.
Yes, sir.
Okay.
She said that.
Would you like to weigh in at this point, counsel?
Your Honor, I don't really want to get into a back and forth of everything, but I think the court is maybe seeing partly what's going on.
Right.
Obviously, I have advised that it's my duty to fight and follow my client's wishes, no matter whether I think it's the correct choice or not. So I would counter that representation as to what.
Am I correct in assuming you're prepared to hold a preliminary exam?
Of course, Your Honor, yes.
Do you want an exam?
If that's what, I'm not sure how the process goes, sir.
Okay, then ask
I'm
questions.
here.
Then ask questions. Here's the way it works. You've been charged with a felony.
Right. Yes,
Understood, okay? There's a preliminary exam process in place that if you want, as a defendant, if you want to make the prosecutor prove their case to a certain level so they can get past a gatekeeper like me,
yes, sir.
then you hold a probable cause hearing. At that hearing, the prosecutor's office has to prove two things. There was a crime committed and there's reason to believe that you had something to do with the commission. That's fairly low standard. But if both of those questions are answered by myself today, by the judge, with yes, then the case moves forward to circuit court level for further resolution. There can be a deal made, there can be a trial held, there can be motions filed. Further things happen at that stage.
Yes, sir.
The other option is the defense attorney and the defendant might agree that based on the facts and the law that we're dealing with on a particular file, there's really no reason to have the exam. Let's just agree that there's reason to send it downtown. We'll go downtown and continue the fight. That's the process.
Okay.
Today was scheduled for that probable cause conference, a preliminary exam.
Yes, sir.
All right. If you want that, she's here to do it. They're ready to go. That's not saying you're guilty or not guilty. It's just saying that's the next step in the process if you choose to go that route.
Yes, sir.
So to say, I'm not going to take an exam today because I don't want to admit my guilt, you're not admitting guilt.
Sir, I just was saying that I was not guilty, and she said that there was she would rather not be my attorney.
There was a what?
I didn't ask her to not be my.
She said what?
She said she'd rather not be my attorney.
Okay, sir, I don't believe that. I mean, maybe there's a miscommunication somewhere. Once again, are you prepared for the exam?
Yes, Your Honor, I am prepared.
He's ready, or the prosecutor's office is ready. I'm not sure who's going to hold the exam. She's ready. If you want an exam, we can do it today.
I'm fine with that, sir. I wasn't saying that I didn't want her as my attorney. She said she'd rather not be my attorney.
Okay, then let's have an exam.
Okay, yes, sir.
All right. Let's get a witness on the stand. Who's the first witness?
Your Honor, before we call our first witness, we are asking a mutual order of sequestration with the exception of the officer in charge as well, Detective Long. And then we will also be admitting a copy of the lab report in this case that shows that the drugs were tested positive for methamphetamine under 76611B.
Anything from the defense on that?
No objection, Your Honor, to either. I'm sorry, are you just doing a true narc? I'm sorry.
The drug report.
Right, but do you have the MSB drug report?
We do not.
Well, first things first, as to the sequestration
No
order.
objection to sequestration, Your Honor.
Granted. All right. So what do we have for a report? I'm sorry.
Okay, so they just have a true narc scan.
Okay.
I would object just as to that being a preliminary analysis.
Okay. I'm not familiar with the true narc scan. I don't even know what that is. What is that? I don't know that I've ever heard that phrase. That's
Yeah. And then just for the record, Mohammed, on behalf of the people, Judge True Narc report is a drug scan that the OIC of the case conducted a test of the drugs, and the analysis of the drug was that the drug that was recovered in this case tested positive for methamphetamine. So it's similar to the MSP lab one, but it's not the same machine. It's not MSP who conducted the test.
It's more like a preliminary test.
Yes, and it was conducted by the OIC.
Okay. All right. So it's actually it's actually an instrument that does a limited of some kind analysis of a substance.
Yes, it's a drug report. The one we're introducing is a True Narc scan report, which is
okay. How long have we been using those, Detective?
Actually, that's what MSD uses now for preliminary stuff. We purchase our own to save the hassle.
How have I not heard of this before?
Because they always do that other testing through MSP's lab, and that's what's actually admitted in court. So I'm a little bit, I guess I would just ask the people under what authority they're relying on this preliminary test, and also to lay a foundation.
Stop, you're taking my question. What's the authority for using this instead of an MSP report?
Well, we don't have an MSP lab report, and so this is going to be used to show that, by probable cause that the drugs that were recovered in this case were methamphetamine.
Okay, I understand you don't have the MSP report. My question is, what's the authority for allowing that instead of an MSP report?
Well, it comes under 76611B. It's a drug report associated with the case. I can pull up the rule and find out exactly.
Pull it up, because I'm going to have to look at it.
All right.
That's actually what MSP does now. Unless it goes through the trials.
Is this the way they're trying to keep up with the backlog? I'm assuming this is a lot faster than full-blown analysis.
40,000 pieces of equipment scans over 500 different substances.
Louder for Heather.
It's a device that scans over 500 different substances.
And if you know, how many analysis or how many substances can be analyzed in a day or an hour? I'm assuming it's a lot more than the full-blown lab.
It's a pre-test. You scan the substance and you do a post, so you do several a day.
Okay.
I mean, to do one of those in 5 days in less than 5 minutes.
Okay. All right. Mr. Monterey, do you have any argument why that shouldn't be good enough for a PC standard?
Your Honor, I guess I would just, my only concern is the reliability of the testing, and there's a reason that, every other drug case I deal with, the MSP lab is what is used, and there's a reason that, departments are sending stuff to a lab for the further testing.
Right.
So I guess that would be my concern, the reliability of it.
Yeah. I'll allow it for probable cause conference. Somebody's got to make the first rule.
In
Obviously, it's fixable at trial.
And just for the record, if it wasn't to be permitted under 76611B, we would just introduce it through the officer in charge, because he's the one who conducted the drug test, and we could lay foundation and introduce it.
I'll allow it for PC.
All right, thank you.
All right. Next issue. Ready for witness?
Yes, Your Honor. The people call Police Officer Mowbray to the stand.
Officer, come on up. Watch your step on my ramp. Raise your right hand. Swear affirm, tell the truth, the whole truth, and nothing but the truth. Settle in. State your name. Spell your last.
Curtis Mowbray, last Mowbray.
Thank you.
Your Honor, may we publish the true narc scan report to the court?
Please.
May I approach?
Yep. Do you have a copy for defense?
I have a copy.
Okay, thank you. Thanks.
Good afternoon, Officer Mowbray. Could you please restate your name for the record?
Curtis Mowbray.
Are you currently employed?
Yes, I am.
Where?
Van Buren Township Police Department,
Are you in any sort of specialized unit?
patrol unit.
And for how long have you been doing this for?
7.5 years in Van Buren Township, 4 years in Roswell, New Mexico.
Okay, and were you employed in this capacity on the date of May 5th, 2024?
Yes, I was.
Did your duties as an officer bring you at or near the location of 50955 South I-94 Service Drive in the Township of Van Buren, County of Wayne?
Yes.
What brought you there?
A male subject, later identified as Mr. Wayne Bales, called dispatch and advised he believed someone had broken into his garage.
Okay, and upon making this arrival, were you alone or were you with any partners?
I was with a partner,
Who was the partner?
Officer McGregor.
And were you in a squad car or foot patrol?
Yes,
Squad
patrol
car?
car,
Okay, was it fully or partially marked?
fully marked,
And were you in full or modified uniform?
fully marked uniform.
Okay, and upon making this location, or prior to making this location, did you do any sort of check on the caller?
Yes, I did. While en route, dispatch advised that during the lean SOS check.
Objection, hearsay.
While en route to the call, I conducted a lean SOS check on my in-car computer system on Mr. Wayne Bales, and it showed that he had several outstanding warrants for his arrest out of our agency.
Okay, and upon arriving to this location, did you make contact with Mr. Bates or Bales?
Yes, I did.
Okay, do you see this person in the courtroom today?
Yes, I did.
Where?
Standing right behind you.
Could you identify a piece of clothing they are in?
Darker colored polo shirt, dark pants,
Okay.
brown shoes.
Could
Noted.
Thank you. Okay, upon arrival, please tell us what happened.
Made contact with Mr. Bales right at the front door of his garage. He stated he believes someone had attempted to break into his garage because the locking mechanism was jammed with some type of debris.
Okay.
I observed surveillance cameras covering several angles right outside the garage. So I asked Mr. Bales if he was able to enter his garage. He said he was able to clear out the locking mechanism, make entry. He didn't observe any damage.
Okay.
I asked if he observed anybody on surveillance cameras. He said no.
Okay, and you said that running the lean check, he had 6 warrants. Did you place the defendant under arrest?
I
These warrants?
verbally placed him under arrest at that time because further investigation revealed that there didn't appear to be any attempt of a breaking and entering into his garage. So at that time, I advised Mr. Bales that he was under arrest for his outstanding warrants. While speaking with Mr. Bales on scene the whole time, I ended up passing a black Ford Edge with 2
Okay,
front
and-
doors that were open. The hood was open.
Okay.
Believing that was Mr. Bales' vehicle, I advised him I was not going to handcuff him out of respect to him,
Okay.
and he would be able to secure his vehicle.
Okay, so upon seeing this vehicle, what, if anything, did you observe the defendant doing?
Repeat
Did
that.
you observe the defendant do anything?
So after advising Mr. Bales that he was going to be placed under arrest and allowing him to go secure his vehicle, I walked right directly next to Mr. Bales. Mr. Bales and I then walked up to the front of the vehicle. I observed Mr. Bales to immediately reach into the engine compartment, in which I observed what he was reaching for. There was several items. One, to be a clear glass smoking device with residue.
Okay, and what else did you observe?
So with that, through my training experience, prior experience and all that, I observed that to be drug paraphernalia. Right directly next to that, I observed a black film container, possibly a pill bottle, but it looked like a black film container. Couldn't see through it. So based on my observations, previous experience, I immediately grabbed Mr. Bales and then placed him under arrest for in handcuffs under arrest for his warrants and then that suspected drug paraphernalia.
Okay, and did you recover these items that you observed?
Yes, after placing Mr. Bales in my patrol unit, I then went back to recover clear glass smoking device with residue and that film container, pill bottle that was directly next to it. Upon opening that container, I observed 2 clear plastic baggies with a white crystalline substance inside. Through training experience, I observed it to be a suspected methamphetamine.
Okay, and did you place these items in evidence?
Yes, I did.
Okay, so after placing the defendant in the vehicle, did you transport him to the police department?
Yes, I did.
Okay, and did he make any statements while you were
He
transporting him?
made several open voluntary statements.
What statements did he make?
May I refer to my report to get specific statements?
Yes, you may. I apologize. If it would refresh your recollection, you may refer to your reports.
Your Honor, at this point, I guess I'm going to object to any statements. He's in custody. He's in handcuffs. Miranda clearly applies. There's been no exception established.
Your Honor, he made these statements voluntarily.
There's been no foundation laid to establish that.
We can lay foundation for that.
All right,
Well, that's my objection.
Okay.
just a second. Mr. Woodard, what are we doing on your file? Okay. All right, I just wanted, if it was quick, I was gonna get you out of here.
Oh, no.
All right, so let's lay a foundation.
Okay, so you stated he was in your vehicle
Yes,
and you were transporting him to the police department?
yes.
Okay, could you tell me what happened when you were transporting him?
While transporting, Mr. Bales made several open voluntary statements to me.
Okay, and did you ask any questions that could have elicited these
No.
statements? You made them voluntarily?
Yes.
Okay, does that satisfy the foundation?
I guess I'm stuck on the word voluntarily. Where are these statements coming from?
I'm not sure if I understand that question. The back seat of the car, I assume.
Understood that, Your Honor. I apologize. I'll make a better point. So he's handcuffed, sitting in the back of a car, and you're saying he's making voluntary statements. I am still lost as to how that's voluntary when Miranda should apply at that point.
You want to respond?
Your Honor, the officer stated that he didn't ask any sort of questions that elicited these responses and that he made these statements on his voluntarily on his free will,
I'll allow it.
I refer to my report to get specific statements that he voluntarily openly stated.
If it would refresh your recollection.
Yes. Mr. Bales stated that inside the plastic baggies contained meth. He forgot he had placed the items on his vehicle. He stated he uses meth occasionally. And he stated he only has $400 to his name and doesn't know how he'll pay for the check.
Okay.
You went back knowing you weren't allowed there? The judge exploded after a defendant admitted he repeatedly returned to his ex's home despite strict no-contact bond conditions. The man tried defending himself by claiming she kept inviting him back, even giving him a key and asking him to pick up his belongings. But the judge wasn't interested in the excuses. Prosecutors revealed Ring camera footage allegedly showed the defendant showing up multiple times, knocking on doors and bedroom windows, calling nonstop, and even confronting the woman outside court. The prosecutor warned the court that the situation was escalating and asked for his bond to be revoked immediately. The defendant insisted the relationship was toxic on both sides and claimed he only returned because the woman kept reaching out first. At one point, he desperately told the judge, "She asked me to come back half a dozen times." But the judge fired back with a brutal reality check. That is not why you're here today. You violated your bond conditions. Then came the line that completely shut the courtroom down. How many times does a woman have to screw you over before you just start ignoring her? Seconds later, the judge revoked the man's bond and sent him back into custody. Do you think the judge made the right call, or was the defendant being set up? Ooh.